Good day everyone and welcome back to our series of video reflection. My name is Arusha and today we are going to discuss on character evidence, a reflection on imputations on the character of the prosecution witness. And today we are referring to the case of R against Turner in King's Bench Division. A character is defined in section 52, 53, 54, 55, which includes both reputation and disposition, but except as provided in section 54, evidence may be given only of general disposition and not of particularly acts by which reputation or disposition is shown. A distinction between a reputation or disposition. A man may be reputed to be a good man, but in reality, he may have a bad disposition, or it appears that the value of evidence as regards disposition of a person depends on a person's mind perception and opportunities to observe person's cleverness to hide his real traits. But a disposition of a man may be made up of many traits, some good or some bad, and only evidence with regard to a particular trait which the witness is having would be of some use. This was outlined in the case in an Indian case, Bhagwan Swarup against State of Maharashtra, 1965. Now we are analyzing the character evidence based on the case of R against Turner, where the prosecutrix was on a visit to her mother where she met 3 or 4 soldiers, of whom was the accused. The other soldiers walked away while the accused remained talking to her. According to the evidence relayed by the prosecution, the accused caught hold of her, tripped her up and hit her in the face when she struggled and tore her undergarments, which succeeded in committing rape on her. The accused was charged with rape. However, the accused claimed the prosecutrix had acted in gross indecency, thereby the accused making an imputation towards the prosecutrix. At trial of the appellant, the judge allowed the accused to be cross-examined, and his counsel, in cross-examination of the prosecutrix, suggested to her that she not merely consented to intercourse but offered to commit an act of gross indecency on the appellant, and the court held that there was doubt regarding the credibility of the witness, where the court cannot find the evidence given to state the details of the woman's conduct which showed that the act of connection was not against will or without a consent. The learned judge in this case allowed the appeal and quashed the convictions as the evidence of previous convictions was inadmissible, where no evidence given state the woman's conduct was not against her will. And we are well aware that in such rape cases, we are ought to prove the intercourse and the non-consent of the women. In this case, the issue was dealt whether the allegation of consent in rape amounts to imputations. Exception to the general rule of character evidence according to section 54 subsection 2 subsection A, where bad character may be adduced, proof that he has committed or has been convicted of any other offence is admissible evidence to show that he is guilty of the offence currently charged. And in this case, Humphrey's judge quoted that the allegations of the complainant consented to sexual intercourse would not amount casting imputations on the character of the prosecution witness. This is because lack of consent as an essential should be a prime element proved by the prosecution. Section 54, subsection 2 provides, an accused charged and called as a witness shall not be asked, and he was asked, is answered, shall not require tending to show he is of bad character. This provision derived from the common law of the United Kingdom Criminal Evidence Act 1898, now replaced by Criminal Justice Act 2003. The defense of consent to a charge of rape is nothing more than a denial by the prosecution on whom lies of proof have established absence of consent on the part of the prosecution. The imputations made were necessary because consent is an essential element of a rape, and it would be prejudice if the accused were not allowed to make imputations towards the witness, as it may result to him being charged. Hence, cross-examination on the appellant's previous conviction shall not be allowed, as it is irrelevant and inadmissible as evidence.